The Courts of Justice Committee will come to order. Clerk will call the roll.
Senator Sadler. Senator Norman. Senator Howell. Senator Lucas. Senator Edwards. Senator McDougal. Senator Stewart.
Here.
Senator Stanley. Senator Reeves.
Yep.
Senator Chapin.
Here.
Senator Deeds.
Here.
Senator Sturdivant.
Here.
Senator Peterson.
Here.
Senator Teeth.
Here.
Senator Obenshain.
Here.
Mr. Chair, inform.
All right. Well, here's what we're going to do this morning. We've got a lot of bills on the docket. I know that the House goes into session at 10, caucus is at 9. We've got a lot of bills on the docket that are identical to or similar to Senate bills. And what I think what we're going to do is go through the bills that are not identical, not similar. I think all the patrons who are here fall into that category, and see if we can plow through as many of those as possible. And then when the House goes to caucus, we'll then try to address as many of the identical or similar bills as we can before we adjourn. So with that, I'm going to start with, yes, can we get Alva? Why don't we start with you?
My bill number 1456. Let me explain the concept of the bill because we've been working on this for 2 years. So, the attorney in my law firm is family law. Says that he uses the word parenting time in his custody agreements instead of visitation. And what he's found is that it really helps in settlement because the people who are non-custodial parents don't like to be called visitors of their kids. So it's a simple little thing. So then I've heard from a bunch of other lawyers that this is often used. You can't use it in a court order because the word visitation is the official rule. So we brought this up last year, and then we delayed it for a year and had the bar, family law bar, look at it. And they all unanimously think it's a great idea, but instead of going through the code and scratching the word visitation and inserting parenting time, the bar thought it was better to do this, to say that the two terms should be synonymous. And the reason is because you might have a not good father, for example, and they don't want to call his time parenting time, they want to call it visitation, or grandma, or other things like that. So it's been fully vetted by the bar, and they believe that this is the right way to do it.
All right. Any member of the committee have any questions for the patron? Anybody here on behalf of the bar?
Mr. Chairman, members of the committee, Jeff Palmer with Reed Smith on behalf of UVA, the Family Law Coalition we work with. Dr. Alvin, I appreciate his willingness to work with this legislation.
All right, thank you. Anybody else in the audience wish to speak to the bill? Seeing nobody?
Move to report.
Second bill be reported. All in, that looks good to council. All right. All in favor, signify by saying aye.
Aye.
All opposed? Bill's reported.
Thank you.
Note your notes. All right. Next. Delegate, Delegate Adams. We got let's look at 2050.
Yes, sir. Thank you, Mr. Chairman, members of the committee. House Bill 2050 amends the statute governing ownership of property by tenants by the entirety. It's in response to the Virginia Supreme Court's ruling in Evans v. Evans, and is the recommendation of the Boyd Graves Conference. It provides clarity to the practice by requiring the signature of both spouses to effectuate any severance of interest in real property that's held in this manner. Essentially, as the court may know, in the case of Evans, there was not a signature of one of the parties during the life of the spouses, but the court, in the case of first impression, said that delivery had been accepted, and that's caused some confusion in the practice, and why this statutory fix is requested.
All right. Jeff, anything you want to add?
Yeah, Jeff Palmer on behalf of the Virginia Bar Association. In
The Evans case, the court had to go through a very detailed fact inquiry to determine whether the deed had been accepted, and so it was not visible on the face of the deed whether it was valid or not. With this legislation, if both spouses have to sign the deed, then it would be clear on the face of the deed whether the deed is valid or not. So you would have the three traditional means of transferring property as specified in entirety: death, divorce, or deed that's signed by both parties.
All right, Mr. Chair.
Sarah Peterson.
What happens if somebody forges their spouse's signature, which happens all the time?
No different than if there's a forgery on another form of deed.
Further question, Mr. Chair. What happens if the other spouse knows about the forgery and ratifies it or accepts it? Would they now be somehow let off the hook by this statute by this change?
Mr. Chairman, members of the committee, I'm not, so in the fact scenario you're presenting, there's been one party signs for himself, the other, and then forges the other spouse's signature, but then the second spouse goes back and ratifies.
Yeah, well, just knows about it and doesn't object.
Previous. I think that would be up to a court to determine how to handle that situation. What the legislation is trying to prevent is that one spouse saddling the other spouse with an undesirable property through a deed that only that one spouse signs. And so the goal is to clarify that there's no question in those situations that both spouses have to sign the deed.
I'm sorry, I'm listening just on one ear, but am I correct that that this bill does not make the situation described by Senator Peterson any better or any worse?
Correct.
Right.
Mr. Chairman,
Sarah Edwards.
describe the case that was, what's it called, Evans versus Evans. What happened there?
In that case, the husband signed a deed over to his wife, and then it was, a generation later that the ownership of the property was in dispute, and so they were looking back at the deed that was accepted, 10 years prior, and so the court had to go through an analysis to determine whether the wife had accepted the deed at the time, and so and much time had passed since the deed had been signed. So in practical situations, it would be difficult for a title examiner or somebody who's doing a look back at property to determine whether such a deed is valid on its face.
So, Mr. Chairman, so what happened was the husband signed it over to the wife and the wife never accepted it? Is that what happened?
In that case, Mr. Chairman, in that case, the court had found that the wife had accepted it, but the fact inquiry that the court had to go through would obviously lead to numerous difficult determinations by title examiners or property purchasers in those instances where the court hasn't ruled on a case to determine whether the deed is in fact valid.
All right. Anybody in the audience wish to address the bill? Bill's before us, I think it's in good form.
I have another question. This is for the council. Is this written properly? I mean, it seems to me to be a little confusing. It's no deed may, it says no interest may be severed by a written instrument unless so forth.
Mr.
Here's property.
Second. Been moved and seconded, the bill be reported. All in favor, signify by saying aye. Aye. All opposed, bill reports. Kelly Adams, we've got 2268 next.
Thank you, Mr. Chairman. HB 2268 involves the ignition interlock system and prosecution for violations. Specifically, it establishes the venue where the violations of the current law prohibiting circumvention or tampering of the devices may be presented. This measure comes by recommendation of the Commission on ASAP. It would allow a prosecution in 3 different locations. One where the offense was committed, second where the defendant resides, And the third, where the order was entered prohibiting the person from operating the motor vehicle.
All right, Mr. Chairman.
Senator McDougall, what's the issue that you're trying to solve? My experience is Jeremy's are always thought where the order was originally entered.
Yes, sir. I believe that in that particular case, the violation may occur outside of the jurisdiction, and perhaps more so now that there's particular monitoring that's available that was not previously. I would
Maybe an actual like one is there.
Morning, Chairman,
Good morning.
members of the committee. In July of
Can you
2016,
tell us?
yeah, I'm sorry, Richard Foy from the Commission on Base Out. In July of 2016, there were new regulations for ignition airlock that came out that required the installation of cameras. Since those cameras have been installed, BASEP's in charge of monitoring reports and viewing the photographs. We're seeing a lot of third-party violations. By that I mean other people blowing breath samples for the offender. The problem is that is a Class 1 misdemeanor in and of itself, and establishing the venue where the offense occurred is the issue.
All right, Senator McDougall.
Chairman, so are you trying, with your change, you're not trying to alter the individual that is required to have an interlock where they're charged, you're trying to deal with other people?
Yes, sir, that's correct. We have, mechanism, obviously they violate the probation and conditions of the restricted license if it's one of the ASAP offenders. But we're seeing several cases per month of people submitting breath samples for the offender. And we turn those over to the Commonwealth Attorney or whoever, but in establishing the venue being where in the state, so that's the issue. And the three conditions here, obviously the first condition, if an officer were to happen to see the offense occur, that would be consistent, in this venue in the presence of the officer. The second condition there about where the person resides, since the person can petition for a restricted license in the area where they live, in the administrative cases, for example, then that's why that provision's there. Also, the third condition is the original court if they're under support.
Senator Norman.
As I read it, it looks like to me that you're providing alternative venues. If you could help me, I represent someone on a DUI case in Williamsburg that requires the ignition airlock, of course. And subsequently, they violated in Wise County, Virginia. Under this bill, would one of the options be to bring the violation in Wise County?
Well, in that case, if he's under ASAP supervision, we're going to go back to the original court. That would be a standard course of action there.
Senator Norman.
That really wasn't my question, and I apologize for not being articulate. It appears to me that the way this bill is written, that it has the conjunctive of or, which leaves it up to the prosecution to determine where they, or ASAP to where they want to bring it, and I don't want to have to go to Wise County for a conviction that took place in Williamsburg. I love Wise County, but
Obviously, we see how it worked out, but I would say from ASAP.
Yeah, the Wise County, Commonwealth County on its feet.
All I can say is, Senator Norman, our standard practice would be to take it back to the court and then put in your case as the first option.
Commissioner?
All right, Senator Edwards.
The purpose of this bill to let you prosecute in Wise County also, either way?
I think he's saying it's not the purpose, but Senator Norman is concerned that it may be the effect. All right. Anybody else wish to be heard on this bill? Step right up.
Good morning, Mr. Chair, members of the committee. My name is Megan Clark, Commonwealth Attorney in Prince Edward County on behalf of the Virginia Association of Commonwealth Attorneys, and we do support this bill. Thank you.
All right, thank you. Now, please tell us how commodious you will be to Senator Norman when it comes to Wise County to defend this bill.
I stood up just to make sure I could say, Senator Norman, you're welcome anytime.
Mr. Chairman, if you could start by telling me what state Wise County is in.
It's not the end of the world, but you can almost see it from here.
All right, the bill's before us.
Mr. Chairman,
Senator McDougal.
all respect, I mean, when I think of, these are criminal prosecutions, these are not civil cases. And you're switching the venue to not where the incident happened, but other places that the defendant could have potentially no contact with whatsoever. And I can't get my mind around doing that and don't see what the issue is. So I would be perfectly fine on it.
Well, this would be an appropriate time.
Motion to generally pass on.
All right, it is, it's been moved to pass by indefinitely. Any discussion? All in favor, signify by saying aye. Aye. All opposed? Vote your nose, please. You're batting 500, delegate. Appreciate it. Thank you, sir. All right. All right, Delegate Lethwich. We've got 1608.
Mr. Chairman, members of the committee,
Oh, I'm sorry. We're going to pass that one by 1515.
this bill simply allows the clerk to transmit certain information electronically to the Commissioners of Revenue and Treasury.
Is this a clerk's bill?
Yes, sir.
All right. Chip, tell us what this does. How it helps your life.
Mr. Chairman, members of the committee, Chip Dix on behalf of the clerks. All it does is to allow, in 4 instances, the clerks to transfer certificates or abstracts by electronic mail or allowing secure remote access as opposed to having to send them in paper. And the treasurers and commissioners are happy with the bill.
So this is only, it only allows transmission of this data from the clerk to the commissioner and the treasurer?
That's correct, sir.
Okay. Anybody have any questions?
Chair.
Anybody from the, yes, sir.
Why can't they do that already? And why can't they just email or just send the next door?
Mr. Chairman, I'd say to Senator Deeds that the statute doesn't permit them to do it electronically. It doesn't permit them to allow secure remote access to the commissioners and the treasurers. And those are the 2 purposes of the bill. It seemed like it wasn't necessary, but when we get audited and we don't provide it in paper, then that creates an issue.
Any other questions? Anybody in the audience wishes to speak to the bill? Bill's before us. So moved and seconded, the bill be reported. All in favor, signify by saying aye. Aye. All opposed? That bill is reported. Delegate Lethwich, we're going to come back to your other bill. We're trying to, I'm sorry. I'm sorry, you've got 1812.
Okay. Mr. Chairman, members of the committee, this was an idea that was brought to me by our local circuit court judge in the city of Chesapeake. And when they were considering defendants for work release, it was his belief that the jail that screens these defendants for work release and tries to find an appropriate place to better serve, they have the pre-sentence report. So this is
Jay, my understanding is this comes from circuit court judge.
Yes, sir.
Can you give us some idea of the situation that generated this request?
Okay, so the trial and the sentencing are 2 days. He's convicted. You have the pre-sentence report. Then it comes and then his attorney says, I will lie, lying over work release. The judge has to make a decision. What the judge would like to do is be able to say he's eligible for it. The sheriff is actually the one who does the background, more thorough background information about the defendant, where he works, and things of those nature. So that he felt like the jail was better position, the sheriff was in a better position to determine whether or not the defendant, based on all the information they gathered, was better suited for the police. So, there's a provision that the information would, I'm sorry. There's a provision that the information would still be extremely confidential, can't be released to any other individual or entity, even the sheriff. That's
Philosophically, you've always viewed the pre-sentence reports as somewhat sensitive. The judge has the option to see them, they're in the file, but they are private. Certainly, in most jurisdictions, the sheriff themselves is not the one that directly administers that oversight, but in a lot of larger jurisdictions, I'm sure Chesapeake is one, they probably have 5, 6, 7 officers that are going through that review process. The chairman, the judge is willing to authorize somebody to be on it. It seems like there are a lot of other ways that the sheriff can apply or an application to be filled out or require information to get there instead of us touch this pre-sentence report, which is a whole different just gives me a lot of causes. The defendant actually has to sign a waiver because it is confidential data of the investigation.
question again, Mr. Chairman.
Would the defendant need to sign some sort of release for that to be?
Not as the bill is worded, but the bill could be amended to require that the defendant either consent to the disclosure or that the court order be upon request of the defendant.
Well, that might be a distinction without, that might be a distinction without difference. Because if I'm a sheriff, I'm going to say, unless you sign this waiver, I'm not going to be in the program, which kind of defeats the whole purpose. We might as well then just directly give it to them. So, which is the part I'm having some challenges with.
Well, I think you saw this as an opportunity to allow more defendants to get into the work release program because the sheriff is in a better position a lot of times to determine whether they're a good candidate.
Senator Stewart, Mr. Chairman, delegate, and it's been a long time since I've done a criminal case that needed a pre-sentence report, but oftentimes there are also information about children and others in that pre-sentence report, and that's part of the reason why we keep it confidential.
Well, I have no doubt, Senator, excuse me, I have no doubt that you're correct about that. Statute does require strict confidence when it goes to the sheriff's office, and I'd be happy to include redaction of certain information.
Steve, what types, again, I've done this in a long time, but what types of other information could be shared in that pre-sentence report that might impact other folks?
Family information, Mr. Chairman, medical information, psychiatric information, prior drug use, criminal history, any number of topics. The depth of pre-sentence reports varies from jurisdiction to jurisdiction, but the whole idea of confidentiality is to permit full disclosure to the court for sentencing purposes of every relevant nuance of a person's background. In contrast, without the bill, I can't imagine why a sheriff would not be able to solicit the information that he needs in some other manner.
Senator Norman.
Mr. Benjamin, on those pre-sentence report, are the victim impact statements considered confidential?
Mr. Chairman, Senator Norman, they are.
Mr. Lumpy. Senator Stewart.
It concerns me. I think the defendant you could amend this bill to have the defendant sign a waiver if they agree to allow this information to go forward. But then you need information about children, family. I've even seen information about friends when they do a pre-sentence report because the idea is to be very thorough for the purposes of sentencing. And that just concerns me. That's one of the reasons why we keep this thing confidential. And so I think I would pass this one by.
probably gave the patron false hope about this behind this legislation. All in favor of passing this by indefinitely signify by saying aye. All opposed? Vote your nose, please. I'm sorry.
I understand.
And I'll take care of your other one.
Are you sure about that?
Ask Mr. Russ. All right. We've got Delegate Collins.
Sure, Mr. Chairman, which, I did.
1692.
Yes, sir, that's the one I believe that, may have a little issue. The Secretary of the Supreme Court has asked me, they have some issues with it. Apparently there's a conference call later on today to discuss with Family Law Coalition who asked me to carry this bill. And I believe they want to make some amendments to it.
All right, well, let's pass this back for today. Without objection, this one will go back for today. I think you've got another bill or two that...
I have one other bill, 1545.
And I think we're going to pass that by temporarily. You don't have any objection to conforming that to ordinance. That's
Yes, sir.
Right. Next, for this paper. Yeah, hang on a second. Chris.
Sir, sorry.
Sir? Yeah, I'm sorry, 1621.
I was a listed senator, so everything was a certain name. Yes, sir. Yes, Mr. Chairman. That one, basically, this fixes a issue that we created years ago when we allowed ancillary misdemeanors to be taken up after a preliminary hearing, so that prosecutors wouldn't have to re-indict or you have to appeal a misdemeanor charge after a preliminary hearing. We streamlined the process, but what we forgot to do was make that a final order for court costs and attorney's fees, so that solves this problem.
All right. Anybody have any questions for the patron? Steve, do you have any thoughts?
A policy consideration for the committee, Mr. Chairman, is this. Here's how this works. If a defendant is charged with a felony and several misdemeanors and decides to waive preliminary hearing on the felony and on the misdemeanors, because, for example, there's an agreement with the prosecution and defense that the whole case would just go to circuit court to be resolved, then nothing of substance is happening at General District Court. It's just the defendant showing up, signing a waiver, and it goes up to circuit court. And so the policy question for the committee is, should the defendant be assessed the costs of that proceeding? They, again, will be assessed costs in circuit court. Should they be assessed costs in General District Court, where all they've done is agree that the case moves to circuit court?
Mr. Benjamin, being the extraordinary criminal defense attorney that you are with national prominence, has it not been your experience that sometimes these decisions are made at the last moment and the court-appointed attorney has prepared a case and interviewed the client?
Absolutely. But the court-appointed attorney will still be paid.
Senator McDougall. Mr. Benjamin, if they're waiving, the logic is that since they're waiving that in certain courts, they're not putting the case on in district court, why would we pay them for either one? So, if that's the logic, then you wouldn't. But that's not the logic. The logic is that the attorney is going to court, they're preparing for the case, they're trying to get the best result possible for their client, and sometimes that best result is waiving on to circuit court because that's where they're going to have something on pause or there's agreement later on, there's agreement on the sentence. But that shouldn't impact whether the fee is paid or not, because if that's the case, you should just say all felonies get paid in circuit courts unless it's actually dismissed in district court. That's a policy decision we're going to make, because that's what you just articulated should happen. Mr. Chairman.
Mr. Chairman, Senator Rule, that's not at all what I meant. The attorney must be paid. I'm talking about whether the defendant should be assessed the court costs, which do include reimbursement, I suppose, for the court-appointed attorney, but many, many other things.
So, this is the question from Mr. Collins, or represented. So, under this language, we're talking about the taking the court-appointed attorney fees and any cost, which would be that $90-some-odd with a class 1 misdemeanor plus any ancillary courthouse fees and whatnot.
Well, what I would tell Mr. Chairman, how I would answer the senator, is the Supreme Court they didn't fix it, but they gave permission for attorneys to be paid on the ancillary misdemeanors in the general district court. However, the court costs that are associated to the defendant do not get taken up to the circuit court. So if you might have one felony and 12 misdemeanors, so those 12 misdemeanors, the court costs and that are associated with those do not get transferred up to the circuit court. And of course, just to answer the senator's question, I think also on a policy question, if it begins in general district court, the general district court clerk's office is the one who's done all the work in preparing the files, sending out subpoenas, and alike. So all the beginning work has happened there. So the court costs that begin in general district court might finish the circuit court, but the general district court is where the court started, and unfortunately, the two clerk's offices don't share in the costs associated with the prosecution.
Mr. Chairman, I have a question.
Senator Edwards.
Currently, the defendant is assessed for the attorney's fees, but not for the court costs at the general district court. And you just want to make sure the defendant at the circuit court level pays for the costs as well. Is that right?
Yes, sir. We're not changing. As it stands now, if the Commonwealth Attorney wanted to make sure, in some jurisdictions doing this, if the Commonwealth Attorney decides, I want to make sure the court costs are associated with the defendant, they can dismiss the misdemeanors and then bring them back up to circuit court. That's an extra step for the prosecutors. The reason we put this in, the policy decision for this was so the prosecutors and clerks wouldn't have to do that extra step. It would just seamlessly go up with the felony.
Well, Mr. Chairman, if the prosecutor dismisses the misdemeanor and then brings it back, those costs are not associated when it's brought back.
Correct. But the other option is to try each one of the misdemeanors. And if they're convicted of each one of those misdemeanors and then appeal it, then the court costs would be associated with that. So there's three ways of doing things. I think what happened was when they decided the answer to misdemeanors, all this is saying is when we do that, we're treating it as a final order for misdemeanors.
Mr. Chairman,
Senator Edwards.
right now the prosecutor is getting a break by not having to try the case at the district court level.
Correct.
I'm not sure why we need the bill.
Mr. Stewart.
Mr. Chairman, I'd like to make a little more out of this than we probably need to. And the fact of the matter is when you've got these misdemeanors that are being processed in the general district court, the clerk is still having to process them. And I'm not sure, I know that if the court-appointed attorneys didn't get paid, it would be a mess, because they don't get paid much to start with. And I'm not sure how we would assess court-appointed attorneys' fees and not assess court costs when the clerk has to process all these things. So I think it's a very simple policy matter, and I know that we're for the second.
Mr. Chair. All right, it's been moved and seconded to report the bill. Senator Peake.
And this may be a question for the council, but it seems if we're going to do this and assess some costs, and all they're just going to be forced to appeal the general district case, they don't have to pay the costs at that time. If they're not going to pay the cost, if the whole case is getting set up, they're going to wait until the whole case is done. They're not going to pay the cost for 12 misdemeanors.
Mr. Chairman, Senator, they already, what it does is if someone is convicted of the misdemeanor and appeal it to go up with their felony, the court costs are associated with that.
They're not paid. They're not paid in general district court.
Well, the general district court will get their money once the case is concluded up the circuit court. So if the way it is right now, they transfer the misdemeanors up to circuit court along with the felony, but because it's not a final order, there are no court costs associated. So all the work that General District Court is doing, so you might have one felony, 12 misdemeanors. Each misdemeanor that they put together a file, they put a separate file and do the work, they're not getting reimbursed for that.
And, Mr. Chair, so when it goes up 12 misdemeanors or felony, they get assessed the cost for 12 misdemeanors, and they go to circuit court, they plead it out, they plead guilty to 3 misdemeanors, what happens?
The court costs are associated, not only the General District Court costs are associated. As it stands now, they said that there is no court cost for General District Courts. If the bill passes, what it does is that there'll be General District Court costs associated also with circuit court, and then the General District Court would get their money, would get their court costs reimbursed back down the line.
All right, we've got a motion, seconded, to report the bill. Anybody from the audience wish to address this before we move forward? Supreme Court have any thoughts?
Eileen Smith with OES of the Supreme Court. I think, Mr. Chairman, in answer to Senator Peake's question, if they're convicted in circuit court, then from an implementation standpoint, then those General District Court costs would be applied. If they're not convicted, let's say of the example you gave, they're convicted of 3 but not the other 9, then I don't think those General District Court costs would be assessed. The other just comment is I think from an implementation standpoint, we can do this. I think it would just be the fixed fees that would be assessed in General District Court because they haven't been convicted. The clerk wouldn't necessarily know all the extra fees, and there aren't that many extra fees. Most of them are incorporated in the fixed fee. But that, from an implementation standpoint, we can do that, but I think that's how we would do it.
Mr. Chairman, aren't you doubling up on people? You charge them at the General District Court level, you charge them again at the circuit court level.
Well, I think that's the question before the committee. We have no position on that.
All right, the bill's before us. All in favor of reporting, signify by saying aye. Aye. All opposed?
No.
Why don't you call the roll?
Senator Sadlow. Senator Norman. Senator Howe. Senator Lucas. Senator Edwards.
No.
Senator McDougal.
Yes.
Senator Stewart.
Yes.
Senator Stanley.
Yes.
Senator Reeves.
Aye.
Senator Chapin.
Yes.
Senator Deeds.
No.
Senator Sturdivant.
Yes.
Senator Peterson. Senator Peake.
No.
Senator Obenshain.
Yes.
7 ayes, 7 nays.
All right, the bill continues to lie within the breast of the committee. Make a note of that one. All right. Thank you, Delegate. We've got next Delegate Krisak. Pronounced that right?
You did, Teresa. So check your name. 1560, aliens convicted of certain felonies. This bill is requested by the Department of Corrections and has the support of state police. Currently, what this strictly addresses is how probation officers communicate suspected aliens to state police criminal records exchange. Right now, the code requires state police to communicate only on paper, on forms provided, see line 19. So the state police cannot propose changing how they receive the information until this wording in the code is amended from requiring a specific form to a format that they approve, which presumably would be email. Once this is changed, they're willing to work with the appropriate agency to develop the electronic or the other means of transferring that information. So it's just an easy, good government bill.
Well, let's see what the state police thinks of this. I assume they think it's a good government bill, too.
Department of Corrections is here.
Do you have, okay.
Hi, Marie Varga, Department of Corrections. We've worked with state police on this bill. We've tried to work on a better way to provide electronic recording as opposed to mailing a form in, but they can't even enter the conversation until the code is changed from form provided by to format approved by.
state police offended that somebody doesn't like your forms?
Mr. Chairman, Keenan Hook, former state police.
All right.
This is a joint collaborative.
It's been moved and seconded. Bill be reported. All in favor, signify by saying aye. Aye. All opposed? All right. Next we've got Elliot Campbell. Looking at you and Elliot Luposse and Elliot Garrett. I know that you've got one, but there are 6 here. We're going to try and get through these in 15 minutes. All right, Elliot Campbell, help us. All right, Delegate Campbell, 1580.
Mr. Chairman, members of the committee, House Bill 1580 provides for an amendment to the code section that will allow for Child Protective Services workers, other employees of the Department of Social Services to possess child pornography in the course of their investigation.
So tell us that this allows Child Protective Services to possess child pornography. Why is this necessary?
As members of the committee are well aware, quite often sexual abuse charges initiated at the Department of Social Services level. A family member or some interested party makes a complaint to the department. Investigators go out and investigate, and in the course of that investigation, they may come into possession of photographs or thumb drives. And I apologize for asking you these questions quickly, but have there been any prosecutions of Child Protective Services workers for this conduct? I mean, it would seem to me that our good prosecutors in Virginia would exercise some discretion. I agree, and I'm not suggesting there has been any prosecutions. However, you know, it could be a very uncomfortable question that one gets asked during the course of a jury trial about whether you have a right to possess that during the course of your investigations. Clearly, they're not allowed they're not given coverage by the statute to do so. So it is a technical violation of the law for them to be possessing the same. I'm not aware of any prosecutions, however.
Senator Stewart.
Mr. Chairman, I guess my question would be, is evidence like any other evidence? Does that mean that all kinds of evidence that an investigator possesses now is a technical violation of the law? I'm pretty confused on this. It's not theirs. It's not their personal possession. It is evidence in their custody.
It theoretically would be, I agree. It would be evidence, but there's obviously coverage for law enforcement officers within that statute to possess the same. And I don't see the distinction between providing coverage for the law enforcement officer but not the Child Protective Services investigator.
So there is a provision that excludes this for law enforcement?
Yes, under that code section. And you potentially even get into chain of custody issues there that could get dicey during the course of the trial.
Mr. Benjamin, any thoughts? They've done this narrowly and find the permission to possession for a bona fide purpose and exclude any kind of protection that might be afforded to some extrajudicial use or some CPS worker who retained it for personal use.
In a word, no. Let's say you're one of these people. You're an employee of a local Department of Social Services, and you come across child porn. Well, it ends up in your home, and your defense is, I was bringing it into the office tomorrow. I collected this in the course of my investigation. It just creates a huge loophole. And this particular statute is one that the committee, as a matter of policy, might hesitate to start what we refer to as Christmas treeing. I also, since the point was made, Mr. Chairman, by someone else, I don't think that we have this sort of an exception under the drug laws, for example. So a police officer seizing drugs as part of his duties is in possession of them, but I don't recall that we have an exception saying that a police officer is not prohibited from possessing Schedule I or Schedule II drugs. It's just not necessary.
You know, I get the Christmas tree effect on it, but I think we've already made some oxymoronic decisions here. As you read the existing statute, there is already an exemption for judges. How many judges have we prosecuted? There's already an exemption for law enforcement. Somehow I'm challenged to imagine that a police officer is going to be charged with fraud against him or her by fellow police officers. So, while it is a Christmas tree, I think we've already crossed the Rubicon on this.
Commonwealth attorneys have any comment on this?
Good morning, Mr. Chairman. I'm Tracy Quackenbush Martin. I'm here on behalf of Virginia Association of Commonwealth Attorneys from Halifax County. We don't have a position on this, and I'm happy to address your concerns.
So you like it or not?
Well, I think that, and I just speak for me personally, sir. I don't think the question necessarily is fully answered by just looking at what we haven't done so far in terms of prosecution. I think it has to do with the efficiency of the criminal justice system. And I can imagine, for instance, when this body allowed the exception for Commonwealth attorneys fairly recently in this statute, was to put folks' minds at ease and to create efficiencies within the criminal justice system. So the issue is, can we imagine situations where someone who is fulfilling their the course of their professional conduct and doesn't want to touch it, and it creates an inefficiency for purposes of examining that case and investigating it. For Commonwealth attorneys, it was problematic before because we had to keep it in the hands of the investigating agencies, or we felt like we were coming close to a line. So we would, for me personally, I would want the DSS workers to be able to collect that rather than hope that it doesn't go away until investigators get there.
Don't you think that if they are acting appropriately, they're going to be conferring closely with you and with the law enforcement, and that their exclusion may wind up making them even more careful with this material?
Well, I think now they have to confer on these things fairly quickly, but I think the issue is really one of policy for this body. Do we want the DSS worker to have to maintain chain of custody and leave it in the possession of an individual until law enforcement gets there? And I would say no.
All right. All right, anybody else in the audience have any comment on this bill? Anybody on the committee have any questions? Everybody?
I have a question.
Sarah Chapin.
Question for the patron. Delia Campbell, now your law firm represents local departments of social services, don't you? Is that right?
Yes, sir.
So you, Mr. Chairman, you have some actual knowledge about how these social workers feel about handling this kind of stuff.
I've represented the departments for about 17 years now, so I can tell you that the chilling effect here is a real issue. You have a CPS worker that might go out on a complaint of some sort of physical abuse, and during the course of that, it's a dynamic environment. And they say, oh, by the way, we've got these photographs of this child who we're concerned about. We would like you to take possession of those. And you've got a CPS worker who, hey, is all of a sudden chilled because this statute doesn't provide coverage for them. And then they make the phone call to the police in that amount of time, the evidence can dissipate because family members change their minds or they realize what they have suddenly set in motion. So I think the statutory change is necessary. Obviously, we're not brought to do it.
Sarah Chapin.
My law firm also represents local departments of social services, and I make the same observations, but for that reason, I'll be making a motion on this.
I have a question, counsel.
Second. Motion's been made to report the bill. Senator Edwards, you have a question?
To avoid the Christmas tree effect, counsel, could you look at line 36 and 37? Would it be better to say the provisions of this section should not apply to any material that is possessed or bona fide, add the word purpose, delete everything to in the course of conducting professional duties? You can avoid the Christmas tree effect.
Mr. Chairman, 6 to 1, half dozen of the other. The committee should bear in mind that it's still a felony under federal law to possess child pornography. There are no exceptions.
All right. The bill's before us. It's been moved and seconded to report the bill. All in favor, signify by saying aye. Aye. All opposed?
No.
Motion goes, please. You have Note your nose, please. Got it, okay. All right. The bill reports 11-4. All right. 1582.
Mr. Chairman, members of the committee, House Bill 1582 is somewhat of a cleanup bill from last year's landmark concealed carry legislation that I know many of you were intimately involved in. As many of you recall, one of the provisions of that legislation was a goal of achieving 50 state reciprocity for Virginia. And in the course of carrying out that, the state of Georgia rejected reciprocity on the grounds that their state law, or Virginia state law, did not substantially mirror Georgia's, and that there was no exception or no allowance for service members between the ages of 18 and 21 to obtain a concealed carry permit. And what this bill essentially would do would conform Virginia's law to mirror Georgia's in that regard to allow for the obtainment of reciprocity.
All right, I see a couple of people jumping to their feet and come address this bill. Anybody in the audience, any member of the committee have any questions for the teacher first? All right, let's hear from supporters and then opponents. We're not going to take 5 minutes, so we don't need that timer.
Philip Bangsley, President of Virginia Citizens Defense League. We support this bill. Many other states allow 18-year-olds even that aren't in the military, and this is a good step for our people that defend our country. Thank you.
All right. Anybody else supporting it? You want to be heard, or are you okay? All right. Yes, sir.
Mr. Chairman, Andrew Ballard, Virginia Centre for Public Safety. We had problems with this based on the 18 to 21. The law doesn't allow these people to drink a beer because they don't think that they're responsible enough to drink a beer. But we're going to allow them to carry a gun in public, and I think that's a little problematic.
All right, thank you. Well, the bill is before the committee.
Move to report. Second.
I'm sorry?
Move to report and a second.
It's been moved and seconded. The bill be reported. Any discussion? Hearing none, all in favor, signify by saying aye. Aye. All opposed?
No.
Please note your nose. 11-4, the bill reports. All right. Now we get Collins. I think we got 1 more. 1589.
Mr. Chairman, House Bill 1589 essentially creates and allows the discretion for the judge to be able to order a legal publication in an electronic medium. Now, all of you certainly know the natural evolution of any publication at this point is moving toward electronic medium. Virginia Press Association is in the process of developing just such a website. Many newspapers are actually moving toward this venue. And what this statutory change would do would be to allow for that publication to take place via the electronic medium and bring us into the 21st century.
So, what would prevent us from showing up someplace where nobody would ever see it?
Well,
Craigslist.
right, I mean, the burden's going to be on the proponent of the publication at court to convince the judge that it's a publication or a website of substantial circulation, to ensure that, that there is a substantial chance that the person might well view it.
So the good cause determination, does that have to be good cause determination, both that electronic means is appropriate in the circumstance and also the identity of the form?
That's the way I would interpret it, yes.
All right.
That was the intent, sir.
Anybody have any questions? Anybody from the audience have any comments on this? Steve, you think it's going to be interpreted that way?
I'm not sure how it would be interpreted. I don't know how I would interpret it. I guess it just leaves it up to the court's discretion as to what constitutes good cause.
Does the good cause, I mean, the court has to determine both good cause and designate or approve the designation of the form.
That's correct. I have a note that a similar subject was raised by a Senate bill, 1368, that had tighter language.
All right.
Mr. Chair.
Senator Peterson.
My recollection is we discussed a bill having to do with foreclosure notice. This appears to be any notice in a civil case. Is that correct?
Is that right?
That's right.
All right. Steve, what was the tighter language that we used? I think it was in Norman's bill.
The language, Mr. Chairman, was on the public government website of the locality served by the court or the website of the circuit court of the city or county which issued the order of publication.
I suspect that, I don't know whether the patron would be amenable, but I suspect that Senator Norma would be amenable to a change to incorporate that language.
And I would so move, having been through this very important state, got the knickers in a wad.
All right. The motion's been made.
This is the first step, obviously, I think, anyway, so.
All right, there's a motion on that. Is there a second? It's been moved and seconded. All in favor of the amendment, signify by saying aye. Aye. All opposed? All right, the bill is amended before us. Anybody from the audience wish to speak to this piece of legislative work?
Mr. Chair.
All right, Senator Peterson.
At least as it's phrased in Delegate Campbell's bill, it's a may. So I guess it would be on a court-by-court basis. I mean, who's going to determine this? Secretary of the Commonwealth? Who's going to make this?
I think it still says may.
Yeah, it still says may.
The court makes the determination.
But if the court, I mean, if I come back and I have an order of publication and the circuit court's going to say, chap, what's the standard of review here? I mean, what am I supposed to make this decision based upon? Because it's not evident from this bill.
Well, I think it's in the course of, I think it's a legal fallacy right now with respect to current orders of publication in newspapers as to whether that newspaper actually, is that your question?
Right, Delegate, I couldn't agree more.
Delegate, you know everybody goes to the front door.
Yeah, right.
I mean, at least right now, if I say, well, I put it in the Washington Post or the Fairfax Connection, or I bought, you know, there's a statutory process and there's some institutional history involved.
Correct.
But if it just says order of publication on an electronic website, well, the only popular electronic websites or the most popular tend to be the most controversial. You know, I mean, there's no website that I can think of, at least, you know, that's sort of county specific in the same way a newspaper is county specific. I mean, honestly, if you said buy a billboard on Route 29, that might be the most efficient means of all. But I think this is just, there's no standard for a court to act upon.
No, I don't think Senator Peterson likes your bill.
Oh, yeah.
All right, it's been moved and seconded that the bill be reported as amended. All in favor, signify by saying aye. Aye. All opposed? No. Yeah, go ahead, call the roll.
Senator Sadlaw. Senator Norman. Senator Howe. Senator Lucas. Senator Edwards.
No.
Senator McDougal.
Aye.
Senator Stewart.
Aye.
Senator Stanley.
No.
Senator Reeves.
Aye.
Senator Chapin. Senator Deeds.
No.
Senator Sturdivant.
Yes.
Senator Peterson. Senator Peake.
Yes.
Senator Obenauer. Eight ayes. Eight ayes, 7 nays.
All right, your bill reports as amended. Thank you very much. Delegate Lukasich, 1641. Thank you for sticking around. Sorry.
Thank you. Mr. Chairman, 1641, this bill will provide that the policy limits in a homeowner's policy shall be disclosed to an injured party making a claim for injuries on property.
This, we already do this for auto liability policies. This conforms the practice for negligence cases with respect to homeowners policies. Right, same rules?
Right. It's a recommendation of Wood Race Congress.
All right. Any member of the committee have any questions? Any member of the audience wish to speak in favor of? The bar is given thumbs up. Anybody in opposition?
Move the report. Second.
All right, it's been moved and seconded that this fine bill be reported. All in favor, signify by saying aye.
Aye.
All opposed, that bill reports. Your next bill, 1647.
Yeah, the problem is someone can come to court in a normal case, in a criminal case, with a plea agreement, and the court can waive the pre-sentence report. However, the way the law is currently written, if you just come in and plead guilty straight up, the court has to do a pre-sentence report. Well, that's not always necessary. And it may very well be that the defendant and the Commonwealth attorney, if they agree to waive the pre-sentence report, they can just do the sentencing that day. So that's what this bill does. It just says, as long as the Commonwealth concurs and the defendant concurs, that the court then can waive the pre-sentence report and just go ahead and proceed to sentencing the person that day.
Senator McDougal.
This is a bill, thank goodness, I could possibly put it in, so I didn't have to, but it's just tightening up a little, I think, a line item where we just missed it. This will make the courts move a lot more efficiently. I move to the board.
Second. That all this does?
All
All right, well, let's withdraw your, all right.
On line 21, after contendere strike unless waived by the defendant, that language was removed, across line 18 when the House made its amendments.
All right, Senator McDougal moves, Senator Norman seconds that amendment. All in favor, signify by saying aye. Aye. All opposed? That amendment is made. Honorable attorneys love this bill? Yes. Okay. Anybody else wish to speak to the bill? It's been moved and seconded the bill be reported. All in favor, signify by saying aye. Aye. All opposed? That bill is reported. And I think that's it for you. I think we've got a conforming bill that will get to Delegate Mieres.
Thank you.
$14.48. Delegate Hope, I'm sorry, you're away. You've got two bills. $14.48.
Yes, sir. Mr. Chairman, this bill is just a technical correction to fix the self-settled spending trust statute. It's a recommendation of the Virginia Bar Association Will Trust in the State section. It only fixes a technical error related to who can serve as a trustee. Mr. Palmer is here, also helping answer any questions.
So, for a spendthrift trust, this allows entities other than bank or trust company to serve?
Correct, Mr. Chairman, Jeff Palmer on behalf of the Virginia Bar Association. We think that when this title was recodified, the reference to Title 6.2, which only takes into account banks and trust companies, was added, but that excludes law firms and charitable organizations that can also serve as trustees of the types of trusts.
But this opens it up beyond that to anybody can serve as a trustee, can't they?
Yeah, if they're authorized by law to act as a trustee and some other place, then yes, sir.
Mr. Chairman, I don't know that anything's wrong, but could it be I guess the beneficiary of the trust who's serving as trustee?
No, sir.
Why?
Because they haven't been authorized by law to act as a trustee.
Mr. Chairman? A natural person residing within the Commonwealth, anybody who's a natural person.
And on the next line says, yes. Oh, I stand corrected. Yes, sir.
I'm sorry?
I recognize the senator's point. I stand corrected.
My point or his point?
Both of yours.
All right, so anybody can serve as a trustee.
Right.
Do we, is that, a spendthrift trust is essentially to prevent, it's set up to prevent a wayward child perhaps from blowing through their inheritance or amount set aside for that child or that beneficiary. Does this not have the potential of defeating the purpose of the creator of the trust?
Mr. Chairman, with if the representatives of the Wills Trust and Estate section couldn't be here this morning, if the committee's willing, I can have them be here at the next meeting to address specific questions regarding the Spendthrift Trust.
Maybe we ought to.
Thank you.
I'm sorry. All right, I'll go back to the day without objection. Can we vote 1492?
Thank you, Mr. Chairman. For the committee. 1492 was brought to me by one of the family law attorneys in my area. It would give the courts the express authority to order child support payments and also able accounts for the disabled to be put in these accounts upon the request of the parent. If the child support is higher than what the SSI is, frequently have situations where people get kicked off of SSI, and in many cases they lose their services. So there's some places where the judge doesn't think that they have this express authority to order child support payments into one of these accounts, and this is what the bill does.
All right. Anybody have any questions of the patron? Do you have anybody who wishes to speak in favor of this, or
The Family Law Coalition supported the bill. I'm open here.
all right, Family Law Coalition, Bar supports this. Anybody in opposition? Hearing none, bills before us. Report. So moved and seconded, bill be reported. All in favor, signify by saying aye. All opposed, that bill reports. Next, you've got House Bill 1493.
Yes, sir, Mr. Chairman. This bill is brought to me by my Commonwealth attorney as well, and this is a technical correction. It adds the words or electronic to the definition of sales draft. Think about now, most of the time when you do any transaction, it's usually with a credit card, and you're swiping your card and you're signing it either with your finger or a stylus. This just makes it easier to prosecute those cases, and simply a definition change is adding those words.
All right. Yes, sir.
Mr. Chairman, Senators, my name is Brian Haskins. I'm the Elizabeth County Commonwealth Attorney, and I'm on behalf of DACA. We support this badly needed change to catch up with technology.
All right.
Second.
All right, it's been moved and seconded that this time bill be reported. All in favor, signify by saying aye. Aye. All opposed, that bill reported. I thought somehow you were from Northern Virginia, not from Pennsylvania County, so.
I guess it's like all of the state.
All right, I think that's it for the patrons who could be here. We had Delegate Gilbert, 1849, which I think Mr. Dix is here, and I think that this bill is a bill at the request of a clerk who felt there was some uncertainty about the extent of his or her authority to issue certain concealed carry permits, and I understand that the clerk is issuing them on this kind of plastic form about the size of the driver's license, and wanted authority, express authority in the code to do that. Is that basically it, Jim?
That is, Mr. Chairman. Jim Dixon, on behalf of the clerks, this is a clerk's bill, and all this does is to change on lines 30, 60, 38 of the existing law the size of the concealed carry permit, and allows the clerk to laminate those. And this is an example with a $30 lamination machine, no cost to the Commonwealth, miscellaneous funds buys this, and it allows people to have a more professional looking concealed carry permit, and it also prevents them from having to pay a fee to replace it of $10. All right, I don't believe there's any opposition.
All right, anybody have any questions? So
Yeah, which bill number?
I'm sorry, that was 1849. We'll deal with this if possible, otherwise we'll pass it by. All right, it's been moved and seconded the bill be reported. All in favor, signify by saying aye. Aye. All opposed, that bill reports. Also, before you leave, Jim, I think that another clerk's bill that we may be able to deal with is House Bill 1630, Delegate Abees.
So, Mr. Chairman, again, this is a clerk's bill, and right now, for trust fund orders, some of those are recorded in the miscellaneous book, some of those in the trust fund order book, and some of those in the civil order book, and some courts, all three. And so, all we're trying to do here is streamline the trust fund order process and say that when you record it in the civil book. And of course, I might say that just about everybody here is a practicing lawyer, that most of these books are electronic. And so it's crazy to have these orders recorded in 3 different books, if you will, within an electronic system. We've reviewed this with OES and also the Office of Public Accounts. It makes a few other technical changes, but there's no opposition to the bill I'm aware of.
OES likes it. They don't have any objection. They're ambivalent about it. All right. All right, it's been moved and seconded that 1630 be reported. All in favor, signify by saying aye. Aye. All opposed, that bill reports. Next, we're going to move to the bills that are identical to or similar to Senate bills. We have 9 bills that, well, first of all, we have 2 that need to be re-referred. House Bill 1426, dealing with emergency custody and the involuntary admission process, needs to be re-referred to the Committee on Education and Health. It's Delegate Garrett's bill. Is there a motion to that effect? It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed, that's re-referred. Also, Senate Bill, or House Bill 1453, dealing with the dispensing of naloxone, needs to be re-referred as well to the Committee on Education and Health. It's been moved and seconded. All in favor, signify by saying aye. All opposed, that bill is re-referred. We have 9 identical bills that were passed out of the Senate uncontested. House bill, and take a look at these. We'll treat these in block unless anybody wants any of these pulled out of the block. These all passed out of committee unanimously and out of the Senate unanimously. House Bill 1479, Delegate Lefwich's, deals with attorney discipline procedures, identical to Senator Norman's 874. House Bill 1516, Delegate Lefwich's surviving spouse elected share, identical to Senator Chapin's 1177. House Bill 1545, Delegate Collins, delayed appeals in criminal cases, is identical to Senator Stanley's 853. House Bill 1608, Delegate Lefwich's Uniform Fiduciary Access to Digital Assets Act, which is identical to my Senate Bill 903. House Bill 1617, Delegate Reeves, Legal Malpractice Statute of Limitations Bill, identical to Senator Sturtevant's 1140. Delegate Reeves 1618, non-exoneration of debts on property of decedents, identical to Senator Chapin's 1176. House Bill 1646, Lupasi's form of garnishment summons, identical to Senator McDougal's 1333. That's a joke. Cody. 1652, Lupasi's General District Court of the City of Richmond, identical to Senator McDougal's 1273, and Delegate Hope's 1882, replacing terminology in capital case statute, identical to Senator Howell's 1352 Crime Commission bill. That's the block. Anybody wish any of those to come out of that block?
Mr. Chairman, did you make any disposition on House Bill 1931?
Not yet.
Okay.
All right. It's been moved and seconded that those be reported in the block. All in favor, signify by saying aye. Aye. All opposed? Those bills are reported. Next, we've got House Bill 1921, Delegate Robinson's assault and battery on healthcare providers, which is identical to Senator Sturtevant's. They're reported out of the Courts Committee 10-4 with one abstention, passed the Senate 28-12. Senator Sturtevant moves that the bill be reported. Is there a second? Second. And it's been moved and seconded, and for your information, those who voted against it in committee were Lucas, Edwards, McDougal, and Peterson, with Deeds abstaining. All in favor of reporting, signify by saying aye. Aye. All opposed?
No.
Anybody different? All right. That bill reports 11-4. Next, we have a number of bills that are similar to Senate bills. First is House Bill 1404, dealing with the activation of fire alarms. This is Delegate Coles. It is similar to Senator Stewart's 1054. Senator Stewart moves and Senator McDougal seconds. It deals with the penalty for pulling fire alarms. It passed out of committee 14-0. Senator Stewart moves and Senator McDougal seconds that the bill be conformed and reported. Conformed. Conformed to the Senate substitute. All in favor, signify by saying aye. Aye. All opposed? That bill is reported. Next is House Bill 1713, Delegate Minshews, and I'm sorry, if any member of the audience wishes to be heard on this, and I apologize for blowing through these bills, if you would stand up and step forward, and if I have inadvertently rolled over you and you wish to be heard on any of the bills that we have just taken action on, we'd be happy to undo it to hear you. All right. Next, we've got Delegate Minshews, 1713, dealing with electronic access to non-confidential criminal records, which is similar to my Senate Bill 1044, which passed out of the Courts of Justice Committee 15-0, and I think unanimously out of Senate Finance. Is there a motion to conform and report? So it's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed. Next, we have Delegate Pokies, 1874, dealing with search warrants for customer records from financial institutions. Similar to Senator Norman's 1310, which reported out of courts 15-0 and passed the Senate 40-0. Commonwealth's attorneys are popping up. They love this bill. Well, the amendments will be made if we conform it. All right, it has been moved and seconded that we conform and report. All in favor, signify by saying aye. Aye. All opposed. Next, House Bill 2308, Delegate Wright, carrying a concealed handgun by retired conservation officers, similar to Senator Carrico's 1465, which was reported from courts 15-0, passed the Senate 40-0. Is there a motion to conform and report? It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed. Next, we have one that is similar but was contested. Delegate Wingers, 1432, which is similar to Senator Reeves' switchblade knife bill. Automatic knife bill.
We're going to conform my bill over in the House. It is.
Do you want to accept Senator or Delegate Ware's language? All right, so Senator Reeves prefers the House language, which Senator Delegate Reeves, why don't you tell us how that differs?
On two linemen say added on the bill itself. Let me just quote up, not exactly there, but they added the word lawful before was before recreational activity. That's the only line they add. Just clarifies what kind of recreational activity is by being lawful.
So it has to be a lawful recreational activity. Well, let's hear from folks who want to speak in favor of the bill. Step on up.
We support that.
All right, in opposition to the bill.
Chairman, Andrew Goddard, Virginia Center for Public Safety. We oppose the bill because switchblade knives contain a number of weapons which are designed and only useful as weapons with no other function. But I must admit that I heard that this would help out with roofers and people in confined spaces. Clearly, nobody's ever heard of this thing. You slide it with one hand, and don't worry, it's not got a blade in it, it's a piece of cardboard. I don't want you to think I'm here for another Bowling Green This is available for less than $5. It's legal. It's fantastic for doing all kinds of jobs. And you don't need to have a stabbing knife to do the work that this does. So I think if we're going to allow all mechanical knives, all switchblade knives, without trying to take out the ones that are only used as weapons, I think we're going to head into a lot of trouble.
All right. Yes, ma'am.
Very briefly, Marie Bargo, Department of Corrections, but I'm speaking on behalf of the administration who opposes this bill.
All right.
Mr. Chairman.
Yes.
I have a good question. Why is the Department of Corrections the one talking about this when it would be illegal for anybody to possess any sort of device that could be considered a knife in the department?
I'm not speaking on behalf of the Department of Corrections, just the administration. In this matter, I was asked to stand up and voice it.
Okay. All right. Senator Reeves moves to report Delegate Minshew's bill. Delegate Ware's bill in the form that it came to us. It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? No. 10 to 5, the bill reports. Next, we have Delegate Carr's House Bill 1931, which is similar to Senator Dance's Fair Enforcement Inspectors Bill, which did report from the Senate Courts of Justice Committee 10 to 5, and out of the Senate 30 to 10. And for refresh your recollections, Senators Obenshain, McDougal, Stewart, Reeves, and Chapin voted no, coming out of committee. Senator Lucas moves.
Mr. Chairman, I just want to make one observation. First of all, the Senate bill and House Bill 1931 only extends this to Richmond. But the Hampton River Transit would like to also be included. That language is in the bill that was introduced by Delegate Dan, Senator Dan, and it also was.
Maybe you'd like to move to conform to the form that the bill led to Senate.
Yes, that's correct.
All right. Senator Lucas moves and Senator Howell seconds the motion to conform that to Senate Bill 1172.
Correct.
Okay. Any discussion? Anybody wish to be heard on that? Yes, ma'am.
Good morning, Mr. Chairman, members of the committee. I'm Lisa Guthrie with the Virginia Transit Association, and we've supported both bills, but we prefer the Senate bill because it has statewide application with local options so that other transit systems will be able to utilize this without having to come back every year and add another locality.
I think you're about to get it. All right. Anybody else? All in favor of reporting, signify by saying aye. Aye. All opposed? No. Probably the same no's. 10 to 5? All right, bill reports 10 to 5. And I believe that's all that we have. Is that right? Yes. So we've gone through 30 bills today? 32 bills, not bad for an hour and a half's worth of work. All right, committee will rise.